AirAsia. We submit two major bases for this. First, that the St. Pierre Island legally belongs to AirAsia, pursuant to the United Nations Convention on the Law of the Sea. Article 3 of the United Nations Convention on the Law of the Sea regarding the breadth of the territorial sea states that every state has the right to establish the breadth of its territorial sea up to a limit not exceeding 12 nautical miles, measured from baselines determined in accordance with this convention. If I may, I would like to request for Your Excellency's attention to the Moot problem. Page 7, paragraph 6, line 3. Okay, here it states that the St. Pierre Island belonged to AirAsia. It is a fact that has been confirmed by both AirAsia and Ronaval. As both states are parties to the United Nations Convention of the Law of the Sea, they are both bound by this convention. And pursuant to the convention, AirAsia does have the right to establish that its territorial sea is within the limit of 12 nautical miles. As it does not exceed the limit determined by the convention, the St. Pierre Island is rightfully the territory of AirAsia. Therefore, as St. Pierre Island is 12 nautical miles of AirAsia, the territory legally belongs to AirAsia in compliance with the convention. The second basis for my submission is that Ronaval has no proof that the St. Pierre Island belongs to it. The burden of proof remains at all times on the respondents to produce specific proof that it has sovereignty over St. Pierre Island and has carried out acts of a sovereign nature on or over the island. In the case of the Temple of Preah Vihar, Cambodia and Thailand in 1962, it stated that the burden of proof in respect of the facts and the contentions on which the respective claims of the parties are based will, of course, lie on the party asserting or putting them forward. The establishment of a lighthouse and a helipad cannot be considered as having performed acts of a sovereign nature over the St. Pierre Island. Ronaval claims to have administered the island of St. Pierre through these establishments. However, if we look at the case concerning sovereignty over Pulau Ligatan and Pulau Simpadan, Indonesia and Malaysia, the court observed that the construction and operation of lighthouses and navigational aids are not normally considered manifestations of state authority. In the case, the court also referred to its judgment on the case concerning maritime delimitation and territorial questions between Qatar and Bahrain, which stated that the construction of navigational aids, on the other hand, can be legally relevant in the case of very small islands. However, even if this was taken into consideration, St. Pierre Island is not defined island. Therefore, the construction of a lighthouse and a helipad by the respondents cannot be taken into account as legally relevant or as having performed acts of the sovereign nature. So the activities of Ronaval on St. Pierre Island are insufficient to support Ronaval's claim that it has sovereignty over the island. It is unable to prove.
Adrian.
Yes, Your Excellency.
You try to differentiate between the authority and the existing fact mentioned that it is not large enough for the island to be considered as something which would constitute a sovereignty. Okay, so what, in your opinion, is a large island?
In this case, I'm only referring to the facts that has been established, that is written in the Moot problem, and nowhere in the Moot problem did it state the size of St. Pierre Island. It did not state that St. Pierre Island is a very small island, and thus it cannot be presumed to be a very small island. So So the actions taken by Ronneval on St. Pierre Island cannot be defined as having performed acts of a sovereign nature.
So you are trying to suggest that the island, in the fact, St. Pierre Island is the same or smaller than the authority you cited just now?
I'm referring to the case between Qatar and Bahrain, which judged that the construction of navigational aids can only be legally relevant in the case of very small islands. However, St. Pierre Island is not defined. Nowhere is it stated in the facts that has been agreed upon by both parties that the St. Pierre Island is considered a very small island. Thus, the actions performed by the respondents cannot be determined or cannot be considered as legally relevant in this case. I hope that answers your question.
Thanks.
Thank you very much. All right, so thus, Ronneval is able to prove that it has the right to claim the island as its own. On behalf of AirAsia, the applicants respectfully request that the court to adjudge and declare that the sovereignty of the St. Pierre Island belongs to AirAsia. Yes.
I have a question for you. You mentioned non-sovereignty, and there's a term called sovereignty rights in the Moot question. Is there any difference between those two terms? And if there any, can you please clarify? Thank you.
Thank you very much for your question, Your Excellency. But unfortunately, I am unable to assist you on that matter. However, the manifestations of state authority is explained in the case of Miniquers and Acreos in 1953. Yes. However, unfortunately, I will not be able to assist you on that matter. If I may proceed with my second submission.
That's okay. Proceed, agent. Thank you.
Okay. Thank you very much, Your Excellency. Our second submission of the applicants is that Imaro can intervene in the ICJ proceedings involving AirAsia and Ronneval. This is because Imaro has the legal right to intervene in the case involving the two parties pursuant to the statute of the court. Article 62 of the Statute of the Court provides that 1. Should a state consider that it has interest of a legal nature which may be affected by the decision in the case, it may submit a request to the court to be permitted to intervene. And second, it shall be for the court to decide upon this request. As Imaro claims that its fishermen have been fishing around the island for centuries, it has an interest of legal nature regarding the sovereignty of the St. Pierre Island. Thus, Imaro will undoubtedly be affected by the decision in this case. Hence, Imaro may submit a request to the court to be permitted to intervene in the case, upon which the court will decide upon the request. Therefore, Imaro has satisfied the first requirement of Article 62 of the Statute of the...
Agent, sorry to interrupt again. You mentioned about the fishing activities surrounding the island. Could you explain or clarify which perhaps treaties or customary international law establishes fishing as the legal right?
In the case of Pulau Ligatan and Sipadan between Indonesia and Malaysia, it is stated that Indonesian states that the waters around Ligatan and Sipadan have traditionally been used by Indonesian fishermen. The court observes, however, that activities by private persons cannot be seen as effective if they do not take place on the basis of official regulations or under governmental authority. The court concluded that the activities relied upon by Indonesia do not constitute acts of having sovereign nature, infecting the intention and will to act in that capacity. This is in relation to this case in which Imaro claimed that fishermen fishing had been fishing around the island for centuries. However, it cannot be considered as an act of sovereign authority over that island itself. Thus, Imaro does have legal interest in regarding the decision of the sovereignty of the island.
Well, I'm trying to understand your argument here. You're saying that Imaro has a legal interest, isn't it? And that legal interest arises from the fishing activities. And the authority that you quoted just now seems to me suggesting the other way around. It says that if the fishing activities cannot be associated with any sovereign authority, then that would not constitute a sovereign act. And that would, of course, does not meet the requirement of a legal interest. Am I right?
Yes, Your Excellency.
So how do you go about this?
Okay, so in the Moot problem, page 8, paragraph 9, Imaro has issued a public statement on its government website declaring that neither AirAsia nor Ronaval was right. In this sense, the government of Imaro has a legal interest in legal interest in this case because they have stated that there were no objections from any countries regarding this practice. I think my time is up.
Yeah, proceed.
Thank you very much for your time. And I will conclude by saying that the applicants acknowledge the right of Imaro to intervene in the ICJ proceedings involving AirAsia and Ronaval. Thank you very much. If I can be of no further assistance to the court, my co-agent, Ms. Divya, will proceed with her submission.
Thank you, Ms. Cameron. Your Excellency, moving on to my third point that AirAsia is exempt from responsibility for providing vulnerable damages for the HMS Gongkeeper and compensation of lost ship. Under the international humanitarian law and international peace and security, international law and conduct of military operation, AirAsia will not be liable to compensate Ronaval for the damages suffered by HMS Gongkeeper. Under the international humanitarian law, Jus in Bello regulates that the conduct of the forces when engaged in war or armed conflict. It is distinct that Jus ad bellum, which regulates the conduct of engaging in war or armed conflict that includes the crime of aggression. Together in the Jus bello and Jus ad bellum comprise the two strands of the laws of war governing all aspects of the international armed conflicts. There are also other customary unwritten rules of war, many which were explored at the Nuremberg trials. So according to Your Excellency, please refer to the Moot problem in page 7, paragraph 5. It is stated that President Harris then ordered 3 nuclear-powered submarines and 4 aircraft carriers to relocate the Barents Sea, and President Amara, fearing the safety of his nation, called Russian President Mr. Putin and asked for military assistance. War is prohibited. The threat or use of force against other states is prohibited by the United Nations Charter since 1945. War has been as an unacceptable means of resolving interstate disputes. As a result, threatening a nation with a military strike is against the humanitarian law. Besides, a state is said that to have undertaken an internationally wrongful conduct, which is a violation of international law when it violates any of its treaties to which it is a signatory, or when it disobeys globally accepted convention and rules. In such circumstances, a state may be found in violation of international law and subject to repercussion. Such jurisdictions are required to discontinue the illegal acts right away and are also given to the duty of compensating the injured. States that violate international law must also provide assurance that these crimes won't happen again in the future. Governments are legally liable for the activities of their officials and can be held accountable for interaction with both other state and private citizens. Besides, hitting naval mines and demand full responsibility, which does not seem right from the perspective of United Nations Convention of the Law of the Sea. Sovereign waters and international waters, since ships of all nations enjoy the right of innocent passage through the territorial sea and archipelagic waters. A state's rights to lie armed mine in this water is tempered by this obligation not to hamper the appropriate passage of foreign ships. This rule derived from both treaty and customary international law. A coastal state is entitled to suspend innocent passage to protect its national security for weapons exercises, but in such circumstances, the suspension must be temporary and only specify area of its territorial sea. In other words, the right to do is exceptional. If a coastal state lay mines in territorial waters and fail to give any warning or notification to vessels of another state that have been rights of access to the passage, it will be in the breach of its international legal obligation. These legal obligations are found in territory and customary international law. Once the security threat terminates and armed mines must be removed from the rendered harmless, while floating mines must be removed or rendered harmless 1 hour after the deploy in any circumstances. The Barents Sea were not regarded as high seas, so the ship lacks legal authority to assert innocent passage. Because passage is innocent so long as it does not adverse to the peace, good and order to security of the coastal state. According to Article 19 of UNCLOS 3, such transit shall be accordance with the Convention and other applicable law of the world. One of the oldest, most widely acceptable principles of public international law is right of the innocent passage of foreign ships through the territorial waters of coastal state. The definition of meaning of passage is found in UNCLOS 3, Article 18. In Article 17 through 32 of the Law of the Sea Convention set down the rules governing the right of innocent passage. The right is well-established principle of international law and is crucial component for territorial sea regime. However, from its inception, this rule has been subject of ongoing, ferocious debate between nations over its legal significance, applicability, and implication. The issue surrounding the unintentional passing of warship is generated the majority contentious discussion and even problems. So both in a Law of the Sea Convention of 1982 and 1958 Geneva Convention have essentially similar clauses regarding innocent passage under the same subsection titles. Therefore, Republic of Brunei is not accountable for claiming that it accidentally hit mines that were set up for security purposes. Conclusion: applicant submit a violation against international humanitarian law and United Nations Convention of the Law of the Sea occurred in the case. Yours Excellency.
Yeah, Agent. I just need some clarification. You mentioned about the international treaties and the established principle, international law, and you mentioned one exception that it should be for a temporary purpose. So, do you think the mines planted by the state is meant for a temporary?
To be
I'm sorry, Agent, you are not audible.
now.
We can't hear you. Agent?
Yes, sorry to taking a long time. The mines are not temporary, but Republic of Renewable is not accountable for claiming because the mines were set up for security purposes.
So you are contradicting yourself because you mentioned earlier on that the only exception allowed the law is that it should be for a temporary purpose only.
I just mentioned that the Russia, sorry, Renewable cannot be able to, sorry, Russia is not cannot be able to compensate because they claim under the innocent passage, and Barentsi is not considered as innocent passage. Yes, Excellency.
Let's proceed.
So, Yours Excellency, I will move on to my fourth issue, which is Russia is not liable to compensate Renewable for the damages inflicted to the HMS Gongjang. For your information, there are two currently administrative regions in Russia. The first one is under President Amara, which are in charge of the south, while the second one is Amen United, a paramilitary organization that will be in charge of the east. However, on the global stage, the majority of the nations regarded both nations belonging to the same nation. So, the following actions, though not all of them, are considered acts of aggression under UN General Assembly resolution, regardless of whether declaration of war has been made. Any military occupation, invasion, or attack on the territory of the state by armed force, regardless of how transient, brought about such invasion, attack, or other annexation by the use of force, stated forces bombing another state territory for the portion of it. The use of any weapons state against the territory of another state, or the use of any force, state ports, or coastline being blocked by the military forces of another state. This definition is based on three criteria, which the act of aggression must be perpetrated by state and can engage the responsibility of both state, and it implies the use of armed force, and it must be reach level of sufficient gravity in order to qualify as such a Security Council and give rise to reaction in self-defense or sanctions imposed by the international community. This definition excludes, yes?
Sorry to interrupt. Can you define what does it mean by a state? You are saying that you have administrative issues, but that is your internal issues. By international law, can you define us? What does it mean by a state? Thank you.
Yours Excellency, state means ports or coastline that being blocked by military forces.
Tell me your authority then, agent.
Pardon? So,
Your authority for your definition, agent.
sorry, Excellency, I couldn't be able to assist you regarding this.
Okay, that's a definition of a state according to international law. It's okay. You may proceed.
So the act of aggression must be perpetrated. Thus, the paramilitary organization, which is Yemen's attack is not responsible, which is not responsible by Russia. For the foregoing reason, I respectfully request the court find favor in favor of Russia and Republic of Renewal on violation of acts under the aggression of UN General Assembly resolution does not apply for Russia. Thank you, Your Excellency.
All right. Thank you, the agent, for the applicant.
Hello, everyone. Am I audible?
Yes.
Good morning, Mr. President, Madam President, Your Excellencies. May it please the court. My name is Nur Fazliana. As the agent of the respondent, the Republic of Roundel, I will spend the next 35 minutes addressing all 4 issues and reserve 1 minute for rebuttal. Your Excellencies, the respondent has 4 issues to submit. The first issue is whether the Saint Peria Island belongs to Roundel. The second issue is whether Imaru cannot intervene in the ICJ proceedings involving Arasia and Roundel. The third issue is whether Arasia is liable to compensate Roundel for the damage suffered by HMS Gonghipo. The fourth issue is whether Arasia is liable to compensate Roundel for the damage suffered by the HMS Gongjini. Unless there is a preliminary questions, I will now proceed with my submission. Turning to my first issue, Your Excellencies, we submit the sovereignty of Saint Peria Island belongs to Roundel. The first ground that we would like to submit is our government has sovereignty towards the Saint Peria Island. Your Excellencies, according to paragraph 6 of the Moot problem, our government, the Republic of Roundel, has controlled the Saint Peria Island for 53 years with no interruption by the applicant. The proof of the government involvement by our government is on the establishment of the lighthouse and the helipad. Thus, Your Excellencies, the applicant's silence manifests acquiescence. Our second ground, Your Excellency, is that the applicant's claim on their cartographer is insufficient to prove their sovereignty over the Saint Peria Island. We would like to highlight paragraph 8 of the Moot problem. The applicant claimed their cartographer had delineated the boundaries of both countries. However, Your Excellencies, according to the case of Botswana and Namibia, the court shall not conclude the cartographic material given the absence of any map officially reflecting the intention of the parties and in the light of the uncertainty and inconsistency of the map submitted by the parties. Your Excellency, the third ground we would like to submit is the act of acquiescence by the applicant indicate the transfer of sovereignty to our government. Your Excellency, acquiescence is the act of no interruption by the applicant. According to McGibbon, it is where the form of silence generally calls for a positive reaction, signifying an objection. The applicant has not shown any protest in the existing establishment by our government throughout the 53 years. Your Excellencies, in the case concerning the sovereignty of Pedra Branca Pulau Batu Putih, Saint Peria Island has satisfied the criteria as a tetra de sovereign. The court shall consider the conduct of the applicant, including their failure to respond to the establishment of our government in the island. Your Excellencies, according to Botswana-Namibia case, the court laid down several criteria for the international law to recognize acquisitive prescription. The conditions of the possession must be a tetra de sovereign, peaceful and uninterrupted, public and endure for a certain length of time. Your Excellencies, our government has fulfilled the acquisition of territory by prescription, where it is the peaceful and continuous exercise of sovereign activities for a long time over the Saint Peria Island. Our government has established the title with 53 years display of state authority, which they have the intention to acquire the Saint Peria Island, and the act of establishing helipad and the lighthouse demonstrate their exercise of sovereign authority. Your Excellencies, based on Huber's theory, our government has exercised state functions by chasing away the applicant's fishermen on the territorial sea of Saint Peria Island. Our government has also displayed a peaceful display by making the applicant's fishermen leave the area instead of launching act of aggression on the fishermen. Your Excellency, the pattern of state authority that our government has exercised is appropriate in the aspect of the character of the Saint Peria Island being established with a lighthouse and a helipad. Your Excellency,
I have a question. You're mentioning about helipads. In your opinion, is the purpose of the helipads make any difference? For instance, if the helipad is for civilian purpose or if it's for military purpose, will that make any difference? What do you think?
yes. Okay. Thank you, Madam President. Yes, Your Excellency, it does make any difference. It shows that our government exercise a military activities in the area. As we all know, the benefit of a lighthouse and helipad, it serves as a navigational aid and to war boats of dangerous areas. It would help our government in exercising their safety and precautions. I hope that answered your question, Madam President. Your Excellencies, back to our point where Saint Peria Island has been exercised peacefully by our government, where they don't use act of aggression in order to chase away the applicant's fishermen. The pattern of state authority that our government has exercised is appropriate. Now I will proceed to my fourth ground, that diverse exercise by our government in the Saint Peria Island. Your Excellencies, according to the case of Eastern Greenland in 1933, the court shall observe the territorial sovereignty of the Saint Peria Island according to how sovereign rights are being exercised. The claimant, the applicant cannot claim their fishing rights as their sovereign rights because there is no evidence that could prove the fishing activity is under the applicant, compared to our government having physical evidence of their sovereign activities on the island. Your Excellency, this shows an absence of the applicant in exercising the sovereignty of the Saint Peria Island. Allow me to take this opportunity to rebut the applicant's ground of there is no proof Saint Peria Island belongs to Rendezvous. Your Excellencies, according to Article 137, Clause 1 of the United Nations Convention on the Law of the Sea, diverse action by a state are a requirement for claiming sovereignty. Our government has established a title of sovereignty of a Saint Peria Island through a succession of sovereign activities. Next, our government has a robust military capability, which is enough to prove that our government ensures peace and no invasion to take place of their territory. Hence, this proves our government has the actual exercise of sovereignty on the island. Therefore, Your Excellencies, we firmly submit the sovereignty of Saint Peria Island belongs to our government.
Agent, I just would like to get a clarification from you. That so here, after all the submissions, you would like to say that a state could go to the other state's territory and then claims the island or claims the territory belongs to the other states, and the claim would be successful if it's not interrupted, although that is within the boundary of the state itself, within the boundary established by the international law itself. Is that what you are trying to say?
Yes, Your Excellency.
So don't you think that this would open up like to so many claims at international law if we allow this to happen, that well the stronger state would take advance over the state having internal problem, such as the one in our case. So don't you think that would happen if we allow this practice?
Your Excellency, it would be the responsible of the original sovereignty for not interrupting any exercise in their state, Your Excellency. That is my question. I hope that answered your question, Your Excellency.
All right, proceed.
Your Excellency, turning to our second issue. We submit that Imaru cannot intervene. Sorry, Your Excellency, for a moment. We submit Imaru cannot intervene in the ICJ proceedings involving Arasia and Rendezvous. Your Excellency, the first ground we would like to submit is the absence of the interest of legal nature by Imaro. According to Article 62 of the Statute of the ICJ, a state shall consider that it has an interest of a legal nature that may be affected by the decision in the case. For example, Your Excellency, in the Continental Shelf case in 1968, the court shall consider that the interest of a legal nature that Imaro had to invoke could not be affected by the case interest of a legal nature. Your Excellency, when it comes to the interest of a legal nature, there are criteria that must be satisfied in order for Imaro to intervene, where firstly, Imaro's interest in the court application of international law does not justify intervention. This is because the court shall only consider Imaro's interest in concreto and in connection with all facts. Secondly, Your Excellencies, Imaro failed to express its legal interest in this case and how that interest related to the decision the court could make after the main proceedings. In Nicaragua against Colombia, it has a legal interest that may be affected by the court's ruling. This nautical region is not enough for the court to let Costa Rica to intervene. Therefore, Your Excellencies, Imaro's attempt to intervene shall be unsuccessful because contrary to Article 62 of the statute, Imaro failed to show that it had a legal interest in the Saint Peria Island that may be affected by the main proceedings. Thirdly, Your Excellencies, Imaro has stated its fishing right need to be protected. However, it does not demonstrate its interest of a legal nature, which may be affected. The decision in this case, it is essential for the Saint Peria Island to be the legal interest Imaro relied on. It is not sufficient for Imaro to only claim no interruption by any country on their fisheries activities. Fourthly, Your Excellency, Imaro's claim on its interest is not the object of a real and concreto claim of the Saint Peria Island. Next, Your Excellency, to determine the scope of Imaro's intervention that is reasonable under Article 62 of the statute, the court must evaluate the possible effect of its eventual judgment on Imaro's legal interest. Imaro may convince the court that it has a legal interest that may be impacted by the case result, and it may be permitted to intervene to defend this case. However, this does not mean Imaro may investigate other aspects of the case. The court must determine the scope of any admissible for Imaro's intervention. Your Excellencies, I'm so sorry for, with your permission, can I have a sip of water? My mouth is pretty dry, sorry. All right, turning to my second ground. The second ground we would like to submit is the absence of a precise object of intervention by Imaro. According to Article 881, Clause 2, Subsection B of the ICJ Rules of Court, an application to intervene under Article 62 of the statute must be set out the precise object of the intervention. Imaro's situation contradicts the case of Nicaragua, where the application of the Article 62 was successful in the case. while Imaru clearly has no precise object of intervention, because Imaru did not set out interests of legal nature which may be affected by the decision in this case. Therefore, Your Excellencies, Imaru cannot apply Article 62 to intervene. We firmly submit Imaru cannot intervene in the ICJ proceedings involving the applicant and our government.
Agent, I would like to refer your attention to the problem, page 8, paragraph 9.
Wait, sir. Okay, yes, yes, Your Excellency.
Imaru has been consistently claimed the island which belongs to them. Okay, and they have been fishing in the areas for centuries. That's another. And it is an established law that every state has the right to possess the unquestioned right to exploit the territorial sea. Okay, and the agent mentioned about the absence of sovereign exercised by the other state, by the applicant. So in other words, your state do not have any interest in the fishing activities in that island, and the applicant state been fishing there and you chase them. Did you also chase the fishermen from Imaru? That's one question. And another question is that if we consider fishing activities as a customary rights of a coastal state, would that make any difference to your submission?
Your Excellencies, St. Perio Island is not high sea where we could apply the. Sorry for a second, Your Excellency. The St. Perio Island is not a high sea where we could apply Article 17 of the UNCLOS, where subject to this convention, ships of all states, whether coastal or landlocked, enjoy right of innocent passage through the territorial sea. If we apply, if we accept the customary rights, yes, they can. But we are still with our submission that St. Perio Island is not the high sea. It is the territorial sea belongs to our government, and therefore we have the right to chase away their fishermen as they don't. We have the right to chase their fishermen as long as we do not use any act of aggression, Your Excellencies. That is my answer.
Did it mention anywhere in the fact that you chased the Imaru's fishermen as well?
Your Excellencies, what I meant is we are allowed to chase them as long as we do not use any act of aggression, Your Excellencies.
All right, proceed.
Turning to our third issue, Your Excellencies, we submit that ARASIA is liable to compensate Rendezvous for the damage suffered by the HMS Gong Hippo. Your Excellency, ARASIA is entitled to establish its territorial sea and exercise its sovereign over it. However, the right of freedom of navigation through innocent passage through the territorial waters of a coastal state without acquiring prior permission may be enjoyed by the vessels of all other states under customary international law of the sea. Your Excellency, the first ground that we would like to submit is that our ship, HMS Gong Hippo, exercised innocent passage our ship engaged in passage through the applicant's territorial sea, and the naval ship was on the high sea. Our government has not violated the Article 17 of the UNCLOS. According to Article 1 of the 1958 Geneva Convention, it explained that all sea areas that are not a component of a state's territorial sea or internal waters are referred as high sea. Your Excellency, the applicants claim that our government's ship had violated the territorial sea by entering its water without permission. However, if we refer to Article 87 of UNCLOS, our ship, just like any other ship, is free to travel to every other country and has access to be on the high sea. In the case of Qatar, Bahrain, Your Excellencies, passage shall be innocent so long as it is not prejudicial to the peace, good order, or security of the coastal state. The non-innocent of passage cannot merely be asserted by the applicants. The confession that the applicant and our government have no official diplomatic relation should not be considered, as the sea is not the official property of a country. It is free and accessible to every state. Therefore, no one can control over the high sea. Your Excellency, the applicant has breached legal obligation by unnecessarily planting naval mines in the sea. Our
Agent,
government...
you mentioned about several grounds, like one of them is the security. If it affects or if it concerns the security, then the state has the right to react in a certain manner. Do you think a naval ship would not pose any threat to the other state?
Your Excellency, if it is a high sea, then every state is accessible to that area. For since high sea is a very wide space, in term for dangerous ship, each state can actually um, choose the option to guard their area nearer, but not in the high state. The plans of the naval mines from the applicant in the middle of the high sea is is irrelevant, Your Excellency. Does that answer your questions?
Could you point to us where exactly you mentioned that the mines were planted in high seas from the fact?
On paragraph 4, page 6, Your Excellency, our government claimed the area is the high sea, and there is no statement by the applicants dissenting our government's claim, Your Excellency. Be that as it may, our submission is still the area is the high sea, and therefore the planting of naval mines is on the high sea, Your Excellency.
Sorry, but I need some explanation here. If the area was not considered, okay, what was said by your state?
I'm sorry, Your Excellency. Do you mind repeating your questions?
Ronable said even if the area was not considered as high seas, the ship was exercising the right to innocent passage. So here it suggests that your government is not confident about the status of the sea, whether it's high sea or not. And plus, this is just one side claim.
Your Excellencies, from other paragraph of the Moot problem after that statement by our government, there is no any dissenting from the applicant side saying that no, it is not a high sea as you claim, Your Excellency. Therefore, we are still with our submission that the area is a high sea.
All right, Thank you.
Your Excellency, I think I may not have enough time to continue for the third issue. Now I will proceed to my fourth issue. The fourth issue is that the applicant is liable to compensate Roundable for the damage suffered by HMS Gongjini. Your Excellency, the attack on our ship HMS Gongjini was an internationally wrongful act of the applicant, as the attack by Aman United is attributable under international law. Aman United has done a wrongful act in attacking our ship at the territorial of our own government. The first ground that we would like to submit is the applicant is responsible for the attack by the Aman United. Your Excellency, according to paragraph 11 of the Moot problem, the applicant claimed the attack by Aman is not under their control, therefore they are not responsible for it. However, Your Excellency, the applicant, Russia, is an autocratic country, as stated in paragraph 1 of the Moot problem. Hence, the applicant is a government where the president, who is the President Amara, holds supreme and absolute power. It is a form of government in which President Amara is unbounded by constitutional limit. Though Russia is divided into the east, where it is controlled by the Aman United, and south, where it is controlled by President Amara. However, Your Excellency's autocracy holds that both administrations are under the same country. Your Excellency, therefore, the applicant cannot claim they are not responsible for the attack by the Aman United, as Aman United is a part of them. The second ground we would like to submit is that application is obligated to compensate our government. Your Excellency.
Before you proceed, do you have any authority to support your argument?
I'm sorry. Sorry. Apologize, Your Excellency. I do not have authority to support my argument, but it is the general definition of autocratic country, Your Excellencies. I hope that will support my argument.
Would you consider the de facto individual leader or government make any difference?
Your Excellency, it is still under the same definition. It does not matter whether the president is under the de facto, but however the main point is the autocratic country, Your Excellency. Your autocratic country where they holds everything under the country. Therefore, Aman United, they may be divided, but they are still under the same country. Therefore, Russia Russia holds the responsibility for everything happens under the state, Your Excellency.
So you're trying to say that simply because the system that they live in is an autocratic system, everything happened is in only one person's responsibility, even if they repeatedly claim that they have no access, they have no they could not have any control over the territory. They have been in conflict for a long period of time. So you would simply close your eyes to all those facts mentioned by the Russia's government.
Your Excellency, it is their responsible for dividing the task into two under an autocratic country. They may not know the Aman United is an aggressive group of people. However, they must know the consequences of putting Aman United under the east area. Yes, that's all, Your Excellency.
Proceed.
So, all right. I may have only 2 minutes. So, onto my second round. We would like to submit that the act of aggression towards our ship was unlawful. Your Excellencies, Russia's act of aggression does not show it is being exercised to protect the sea. In assessing whether the attack by the applicant on the constitute an act of aggression, this court should consider, firstly, the force was used against territory of another state. Secondly, there was a violation of the Jus Cogens norm of non-intervention. Thirdly, the force was of a sufficient character, gravity, and scale to constitute an armed attack. The international obligation of a state arises from the commission of an internationally wrongful act. The act of aggression happened while our government navigated our own territorial. There is no reason for the applicant to use force amounting the wrongful act internationally, as there is no evidence that the aggression happened while protecting the territorial state. The applicant's conduct of an
You're saying about the acts of Russia. How about the act of your own country, Renewable? Well, on 24th December, Renewable launched a concerted attack on Russia's territory. So it's quite similar to what Russia is doing. So you're more or less like the same. So what do you think of that?
Your Excellency, we are not in the same position. Russia did the act of aggression in the first place without any reason. Where in my government, our government did it for in a reply of their action. Your Excellencies, I hope that answer your question.
Okay, thank you.
All right, since my time is up, can I continue with my conclusion? Your Excellency, if there is no question, I will now end my submission. Mr. President, Madam President, we therefore pray to this court to adjudge and declare that St. Perio Island belongs to our government, that Imaro cannot intervene in the ICJ proceedings, that Russia is liable to compensate our government for the damage suffered by HMS Gong Hippo and HMS Gong Ji. Your Excellency, if I can be no further assistance, this concludes the respondent's submission. May it please the court.
Thank you, Agent. We have only one agent for the respondent.
Yes, Your Excellency, I couldn't find any partner for me.
Okay.
You are done, Agent, with your points. You're by yourself only. Is it, Agent?
Yes, Your Excellency.
Timekeeper. Do we have the timekeeper here?
Yes, sir. It's Nurul Hawa Yaakob.
Ms. Nurul Hawa. So we did allocate enough time for agent for the respondent because he's the only agent for our case. Did we?
Yes. Yes, Your Excellency.
Okay then.
Thank you. Closing the session. All right. Any questions for the judges? With that concludes session 1 for today's oral submission. I would like to remind all of the judges to email us the score sheet as soon as the session ends. As a member of the ILSA committee, I would like to thank Dr. Hamidullah and Dr. Nur Zuhaida for sitting down with us as judges in this competition. Thank you all and have a good day. Thank you. Everyone may leave the meeting now.
Thank you, Your Excellencies.
Alright.
Bye.
Thank you very much, Your Excellencies. Thank you, everyone. Thank you, Faziana. Good job.